Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who geek out on this channel regularly, you know that one of the things we are most critical of is hypocrisy, especially political hypocrisy. I hate any politician who's willing to say just about anything in order to get votes. And what I really despise is the ones that make the big, bold, brash statements like, you know, my body, my choice, but then they only mean it in certain instances. I'm going to show you another example of how your Department of Justice has been completely politicized. And while they're screaming to advance the cause of one group, they're also saying, by the way, if we advance that cause, it will make you insane and therefore deprive you of an otherwise inalienable right. So today, let's spend a few minutes, let's get you educated, and let's talk about the DOJ's hypocritical take on cannabis and guns. All right, coming to you from Washington's nicest indoor shooting facility, of course, that's Security Gun Club right here in Woodinville, Washington. The case we're talking about today is the matter of United States v. Harris. It is a challenge to 18 United States Code, Section 922G3. For those of you who've been geeking out on this channel for a while, you know that that is the prohibition against those who use controlled substances from actually having Second Amendment rights. This case is currently kicking around in the United States Court of Appeals for the Third Circuit. And during the course of the briefings on this case, the court had asked for additional authority to talk about the historical analogs that might justify a blanket ban on an occasional cannabis user, because that is the allegations here in this case, is that Mr. Harris is an occasional cannabis user. And as we know, if you are an occasional cannabis user, a daily cannabis user, a once-in-a-blue-moon cannabis user, technically under federal law, you are prohibited from possessing a firearm. Now, let us remember that this is a presidential administration and a political party that has advocated for the legalization of cannabis. Now, I'm not necessarily saying I'm opposed to the legalization of cannabis, and candidly, I live in a state that's had legalized cannabis for a number of years, and despite the fact that we are completely falling apart at the seams, I can assure you that our legalized cannabis industry is not contributing to that problem. So the question here, and we talked about it on this video right here as well, is that, listen, we obviously have a tradition in this country of banning individuals who are dangerous from having access to firearms. I don't think there's really a lot of debating that. But does a marijuana user suddenly become a dangerous person? What about the person who's using cannabis because their doctor has told them to use that in lieu of opiate-based pain-killing drugs? In response to the judge's questions, what does the United States government, the Department of Justice, under the same presidential administration that is declaring that perhaps cannabis should be legalized and moved off the current FDA schedule, what do they say? Well, they say this: drugs and guns are a dangerous combination. Handling firearms safely requires care, caution, and self-control. Characteristics which are compromised by the psychological and physiological effects of illegal drug use. And while that statement is absolutely true, that only describes an individual while they are actually under the influence of that drug. Now, as I go through the rest of these quotes from the Department of Justice's memorandum here, I want you to ask yourself, well, does the same thing happen if a person uses alcohol? Or does the same thing happen if a person uses prescription medications, particularly prescription painkillers or muscle relaxers? Because we all know that there is a significant problem with the use of both of those substances in this nation as well. Now, the Department of Justice states the following: the government maintains that the Second Amendment allows Congress to disarm persons who are not law-abiding responsible citizens. That category includes persons whose possession of firearms would endanger themselves or others. So you can see here that the Department of Justice is immediately arguing for a much more expanded definition of those who can be disarmed. And again, on this video here, we talk significantly about the differences between dangerousness and irresponsible behavior. Section 922G3's restriction on firearms possession by regular unlawful drug users and drug addicts falls comfortably within that principle. But you see, the prohibition here isn't for regular drug users or addicts. It's for any drug users, whether they're addicted or not. Now, the Department of Justice further goes on to then state The court requested the parties' views concerning whether habitual ingestion of regulated substances, including marijuana, is analogous to or triggers conditions analogous to schizophrenia or other mental illnesses or cognitive impairments. The answer is yes, and for that reason, habitual drug users may lawfully be disarmed for as long as they continue to unlawfully use drugs. So the United States government is taking a position that a drug that perhaps should be legalized is likely to make you akin to schizophrenic. And because then you would be mentally ill, there's a rich tradition in the United States history of disarming those people. The Department of Justice further stated, when a user smokes or ingests marijuana, an intoxicating effect may develop within minutes and last about 3 to 4 hours. That is true. They also state, those effects include cognitive impairments like altered perception of time, decreased short-term memory, and impaired perception and motor skills. Sounds a lot like the effects of alcohol. Marijuana intoxication also causes mood fluctuations and feelings of euphoria, decreased inhibition, impaired decision-making, and uninhibited attention and concentration. Also, hauntingly familiar to the effects of alcohol. And again, I would point out that these effects would only be taking place while the person is actually under the influence of that substance. The Department of Justice further claims, like schizophrenia, cannabis use is associated with positive symptoms such as euphoria and paranoia and negative symptoms such as memory loss. Again, sounds hauntingly familiar to alcohol. Now, the United States attempted to connect marijuana use with chronic mental illness, but the best they got was this. More generally, there is a demonstrated correlation between marijuana use and certain mental illness, although the association is not necessarily causal. Did you just hear that? That they believe there's a connection, but they can't really prove any causal connection. Now, of course, anytime the United States has one of their civilian disarmament pieces of legislation under attack, they immediately want to go to, but oh, the horrors, the tragedies that will occur if you overturn this law. And in this case, it's like, well, what about all the other druggies? And this is how the Department of Justice put it. In addition, as the government has noted, despite limiting his claim to Section 922G3's application to marijuana, accepting Harris's arguments necessarily would cast doubt on the statute's constitutionality as applied to other controlled substances. And although their respective effects differ, it cannot be disputed that other controlled substances likewise cause serious cognitive and other impairments that inhibit individuals' ability to safely use firearms. And again, all of that is true when you are under the influence, but all of that is also true for prescription medication and alcohol. So why then is the United States not arguing that people who are occasional users of alcohol should have their firearm rights taken as well? Because that wouldn't serve the political purpose here. The Department of Justice also states, drug users may mishandle firearms or use firearms to commit crimes because of drug-induced changes in physiological functions, cognitive ability, and mood. And I can assure you, if you talk to any criminal defense attorney or any prosecuting attorney, they will tell you that the one drug that most defendants are commonly under the influence of when crime is committed is, shockingly, well, it's alcohol. And then, of course, because you are an occasional cannabis user or a user of controlled substance, what it also means is that your entire life is encapsulated in crime, oftentimes violent crime. And because you now have access to firearms, it's just a matter of time before you are out there actually committing violent drug crimes. Or as the Department of Justice argues, the danger to society posed by an armed drug user extends beyond the risk that he will mishandle firearms while under the influence of drugs. As explained, drug users are also more likely to use firearms to commit crimes to fund their drug habit, engage in violence as part of the drug business or culture, attack police officers who are investigating their drug crimes, and commit suicide. Those risks justify disarming habitual drug users even between periods of drug intoxication. An unpersuasive argument for multiple reasons, but most of which is in the last sentence there, where they're basically resorting back to this balancing test, which of course was soundly rejected by the Bruin Court. Now, the Department of Justice is not done there, because they also argue Section 922G3 complies with the Second Amendment because drug users who possess firearms are apt to retain possession while under the influence. Now, they cite to absolutely no evidence to this, but because you are an illegal drug user and you have a firearm, you are highly likely to be under the influence and in possession of it. Now, they don't make that same argument for chronic drunkards. They don't make that same argument for the people, and you all know these people who are strung out on a cocktail of prescription medication, but they will make that argument for the occasional cannabis user. But listen, ultimately what their argument is that, hey, listen, if you smoke a little weed, you're this close to losing your mind. It's only a matter of time. And therefore, you really should be deemed mentally ill. And because you are mentally ill and mentally defective, you can be disarmed. This is how DOJ put it. Independently, because regular illegal drug use poses a risk of impairment, historical restrictions placed on persons with mental illness also establish a well-established and representative historical analog to justify Section 922G3. Now, of course, they do all this dancing around because the court wanted some type of historical analogs. And when we get beyond the intoxication and all of that stuff, which we've talked about many, many times, what the United States government comes down to is the following laws. A New Jersey law from 1927, a Pennsylvania law from 1931, an Indiana law from 1935, a South Dakota law from 1935, a Washington State law from 1935, and an Alabama law from 1936. And again, obviously, we already know that the time frame for which we are to be taking a look at historical analogs would be either at the time that the Second Amendment was ratified or the time that the 14th Amendment was ratified, both dates far preceding the dates of the statutes that were offered by the Department of Justice. And in the final coup de grace to show that pot users are in fact maniacs, well, this is what the Department of Justice put in their memorandum. Moreover, it has long been understood that a person with a mental illness does not necessarily exhibit symptoms all the time. Blackstone thus defined lunatic as one that hatched lucid intervals, sometimes enjoying his senses and sometimes not. So this particular Justice Department and this particular presidential administration, while they have been talking about legalizing cannabis, also wants you to know that once you start using that substance, you are mentally ill, you are insane, you are a lunatic, and therefore you have deprived yourself of what should have been an inalienable right. You are far too mentally ill, you are far too irresponsible, and you're far too dangerous to ever be in possession of a firearm. The case, once again, is United States v. Harris. We will link up the memorandum down below so you can see what the DOJ had to say for yourself. In the meantime, if you guys got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is right down there in the description box. Now, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.